237 Prince Kumar Mishra.
निकली जरा जजमेंट
पेज नंबर बोलिए.
970.
क्या
काउंटर तो उसने नहीं आया, काउंटर मंगा लेते.
काउंटर देना है आपको?
मैलोट आई थिंक इट इज प्रॉपर.
दो मैटर है, दोनों में दे दीजिए काउंटर, तब सुन लेते हैं. ये भी चाह रहे हैं कि यहीं सुनिए. हालांकि फुल बेंच जरा
सेकेंडली
देखें.
एज अल्टरनेटिव रेमेडी है.
नहीं, इनका आर्गुमेंट था कल कि नहीं, जब तक कन्फिस्केशन नहीं स्टार्ट होता है
जी जी.
तो डिस्ट्रिक्ट मजिस्ट्रेट को पावर नहीं है. लेकिन मुझे दूसरा आइडिया है.
तो उधर उनको पावर ही नहीं.
वही इसीलिए
फॉर द रिलीज ही कैन
कन्फिस्केशन
उसके
बाद
मिस्टर मॉलीज सबमिशन वाज रिपीटेडली सबमिटेड कि डिस्ट्रिक्ट मजिस्ट्रेट को पावर नहीं. तो आई ऑल्सो थॉट कि गिव ए फ्रेश लुक टू द जजमेंट. निकालिए जरा, कहाँ पर है?
पैराग्राफ 23, 24 and 25.
मिल गया. पैराग्राफ 24 and 25. यस. दीजिए जूनियर को, आप थक गए हैं लगता है दिन भर में.
नहीं.
पढ़िए तब.
The Supreme Court therefore drew a distinction between the words return of the essential commodity seized with the words release of the essential commodity seized. The Supreme Court was thus of the view that having regard to the scheme of the Act, the object and purpose of the statute and the mischief it seeks to guard against, the word release is used in a limited sense of release for sale, etc., so that the same becomes available to the consumer public. There is no question of release of the commodity by returning it to the owner before the proceeding for confiscation as well as the termination of the prosecution resulting into acquittal of an offender. Thus, from a conspectus of the aforesaid decision rendered by the Supreme Court.
Just a minute. Therefore, ये finding है.
My lord, after discussing all the judgments, my lord,
It means, according to the full bench,
my lord,
there is no question of release of the commodity by returning it to the owner
my lord,
before the proceeding for confiscation,
my lord.
as well as the termination of the prosecution resulting into acquittal of an offender.
My lord. So even if he drops the proceeding of confiscation, he still cannot release it so long as the prosecution case is still pending before the criminal cases.
आगे देखिए.
Thus, from a conspectus of the aforesaid decision rendered by the Supreme Court as well as on a plain reading of the statute, it is clear and obvious that in case of seizure of any food grains for contravention of any order in terms of Section 3 of the Act from a non-consumer / non-agriculturist, it could only be sold on satisfaction of the collector as an interim measure under the prescribed mode of sale, and in case the order of confiscation was modified or annulled in appeal, and the prosecution instituted for contravention of the order in respect of which the confiscation has been made ends in acquittal of the offender, the price so realized after deducting the expenses in the process of the sale could be returned to the owner.
Yes.
So irrespective of the fact, my lord, that the confiscation proceeding is dropped, he still cannot release it. And even when he has already sold it in terms of 6C, the only thing that can be done is, my lord, that after the the prosecution case ends in an acquittal, the price gets paid to the person whose commodity had been seized.
With interest.
With interest. So neither
27 में जरा ये ना 27 देखिए.
Hello.
Para 27.
thus the first question, this question number A of the reference, is answered accordingly. To specify, the collector under the Central Act has power to release the vehicle, animal, vessel, etc. in case of option exercised by the owner thereof to pay the market price at the date of seizure. There is no such corresponding provision in the State Act. Other conveyance till the conclusion of the criminal prosecution, and if no prosecution is launched until when the collector decides not to confiscate the vehicle, and if the order of confiscation is passed, then only on the annulment of the aforesaid order of confiscation by the appellate authority.
Now in this case, whether the collector has taken any decision to confiscate or not to confiscate?
No, they have not even in the first case, no confiscation case has been initiated.
ठीक है, फाइल कीजिए काउंटर, लिखिए। डिफेक्ट्स भी है इसमें, दोनों में।
Yes, my lord, I would be required to file.
डिफेक्ट्स रिमूव कर दीजिए। बोथ मैटर्स एक अलग अलग कीजिएगा, ऑर्डर दोनों में एक ही होगा। Learned counsel for the petitioner undertakes to remove the defects within 1 week peremptory. Next,
आपका नाम?
Mr. Mirgank Mali, learned senior counsel representing the petitioner,
कुमार सिन्हा, ECT.
submits that the petitioner has no other alternative remedy equally efficacious for the relief spread in this writ application. Full stop. It is submitted that in view of the judgment of the Honorable Full Bench in the case of Baleshwar Roy versus State of Bihar reported in 2018, 4 PLJR, page 970, within bracket, paragraph 23 to 27, bracket closed. The collector has no power under the State Act to release the vehicle or the goods till the conclusion of the criminal prosecution and in case no prosecution has been launched, until the collector decides not to confiscate the vehicle or the goods. Full stop. It is submitted that दोनों में confiscation नहीं स्टार्ट हुआ है,
नहीं दूसरे वाले में हो गया।
it is submitted, इसमें लिखिएगा गणपति